Hi, everybody. This is Katie Widener speaking on behalf of Prince Agency. Thank you all for joining in person and on Facebook Live. We appreciate you spending some time on the first sunny day we've had in a bit. So I have the honor of introducing Catherine Jacobs. She is an estate attorney. She's a partner with Warner Norcross and Judd. Prior to joining Warner Norcross and Judd, she operated her own firm for many years. She's an expert in elder law. She focuses on trusts, special needs trusts, succession planning. She works with the vulnerable as well. She's a wealth of knowledge. We're very thankful to have her. In her spare time, on top of being a partner, she spends a lot of time in our community. She has served on several boards. We have Council to Aging. I actually met Catherine personally through the Rotary when she was president of Rotary so many years ago. So she is just a very giving person, and I think you'll get a wealth of knowledge from her today. So without further ado, I'd like to introduce you to Catherine. Thank you.
So to start off with, I just want to say, because it's a smaller group, and I'm here, and I would like to make sure that you leave having your questions answered. So I put together an agenda just to keep us moving along. But if there's something that you are dying to know, or this burning question, or I say something, please stop me and let's make this a conversation and not just me up here blathering away. Okay? So without further ado, then I'll start. So they had asked me to speak about what is estate planning. And really, and I gave you this outline, and I'm going to follow it a little bit, but I don't want to read it to you because you can do that on your own. So I'm going to talk very broadly around it. So someone asked me what estate planning is. Often I will say it's really emergency planning. It's a bunch of documents that are usually never looked at unless there's an emergency. And usually it's one of two emergencies. Either you're incapacitated or you're dead. Those are the emergencies. And when those documents come out, and they tell us very important things. Who's in charge and what are they supposed to do? And the worst thing that can happen is that you have one of those emergencies, you're incapacitated or you're gone, and there's no set of instructions and there's no one put in charge. Because if that happens, then someone has to get the court involved, because you just don't have the right to say, well, I'm a spouse, or I'm the oldest child, or I'm the best friend, or I'm the only living relative. That doesn't give you any authority to do things unless you have a document that appoints you. And so that is why really estate planning is so important, because none of us know when and if those emergencies will happen. So I have on here, how often should we review our estate plan? And usually that's every 3 to 5 years. But really it's, usually if you do your estate plan, it is good for your life as long as nothing in your life changes. So what could change that might make you want to change your estate plan? Well, maybe a spouse passes away. Maybe a child passes away. Maybe someone you've named to be in charge becomes incapacitated, or they pass away. Those are big life events that would cause you to want to think about changing or updating your estate plan. Changes in law, most people aren't going to know that there's a change in law, but usually even if there's a change in law, your documents are still good. Most estate planning laws will never say your current documents are invalid. The law would never do that to you. They're still valid under the laws that establish them for you. So we're going to spend a lot of time talking about what estate planning documents are, and I'm actually going to do it in two sections. So the first two that I have listed there, durable power of attorney and patient advocate, those are the documents that you need while you're alive. Both of those documents die with you. So sometimes I'll have people call me and they'll say, oh, horrible news, my mom died, but good news, I'm her power of attorney. And so we're all set. And I'll say, well, bad news, that document died with your mom. I don't really say that because that would be kind of harsh, but gently explain to them that if you have those documents, those are only good while you're alive. And those are documents that everybody should have. Every adult should have those. Why? Because once you become an adult, no one can make financial decisions for you or medical decisions for you unless you appoint them under a document. includes a spouse. So if I'm driving home today and I'm in an accident and I become incapacitated, my husband is not able to make financial decisions for me or medical decisions for me unless I've appointed him to do this in my documents. He has priority under the law. So if I didn't have this document and he had to go to court to get appointed, he would have priority as my spouse over, for example, my adult children or someone else. But he couldn't go to the bank tomorrow and say, horrible news, Catherine's incapacitated. I need to take money out of her IRA and I'm her spouse. The bank would say, sorry, can't do it. We need some sort of authority. So a durable power of attorney is very, very important to make sure that if you're incapacitated, you have someone who can make financial decisions for you.
As far as the bank account, just make a joint account will take care of that, right?
Yep. At joint accounts, you don't need a financial power of attorney for that. It's for those individual assets. And so most of us have some individual assets, whether those are retirement accounts, because retirement accounts can only be in the name of the earner, the taxpayer who paid taxes. Another place where we need a durable power of attorney on a joint asset, which I'm glad you brought that up, Rich, because that is important. My husband and I own a home. We own that together. If I was incapacitated and my husband said, well, this house, I don't want to live here anymore. Catherine had to go into assisted living, for example, so I'm going to sell this house. If he didn't have a power of attorney, he would not be able to sell our home without getting appointed as my conservator by the court, because he has no authority to sign a deed on my behalf unless he has a power of attorney to do that. And I find that a lot. I'll have older adults, and maybe one of them is incapacitated and they're downsizing and they want to sell a house, and we don't have a power of attorney to be able to do that. And I should also note, sometimes we don't have an original power of attorney, and that is really important. If you have a power of attorney, make sure that you have the original. So if you already have one, go home and make sure that you have your original, because often clients will call me, oh, mom's incapacitated, we got to sell her house, I'm her agent under power of attorney, and I'll say, okay, get me the original power of attorney, and they'll say, oh, we just have a photocopy, we don't know where the original is. I can't record a deed with a copy of a power of attorney. It has to be the original. So in those scenarios, that person is not going to be able to sell the house. We're going to have to go to court. We're going to have to get someone appointed as a conservator. And so I want to segue just a little bit into that. So what happens if you don't have a power of attorney and someone is incapacitated? You are going to have to petition the court. You're going to have to go to the court and say, Catherine's incapacitated. Someone needs to be able to handle her finances. My spouse could be the petitioner, and he could ask the court to be my conservator. Now, when you become someone's conservator, you have to know that there is a lot of rigmarole involved, and that's a very legal term that I love, rigmarole. So if my husband is appointed my conservator, he is first going to have to post a bond. Even though he is my spouse, the court is going to say, well, you know what, we don't know Mr. Jacobs from Adam, and how do we know that when we appoint him, he's not going to take all of Catherine's money and use it for something not for her? And so even though he's my spouse and we've been married 30 years, they're still going to make him post a bond. He is going to have to file an inventory within 56 days of being appointed, telling the court, here are all the assets in Catherine's name. And then every year, my husband, who shares assets with me and is my spouse, is going to have to file an annual accounting with the court to tell the court how he spent my money, how he took in the money that maybe I got from Social Security. He has to file that accounting every year. And so it is a lot of rigmarole, which is why a power of attorney is such an easy document to have done, and we should all have one. Financial power of attorney can be effective in one of three ways. It can be effective immediately, it can be effective upon incapacity, or it can be sort of a hybrid of that. So my husband and I recently updated our powers of attorney, and we appointed one another to act, and we made them effective immediately. So right now, as I'm giving this presentation to all of you, my husband could be talking to the person who manages my 401k at my office, or the person who manages my IRA. Those are solely in my name. He has the authority to do that right now. And I'm okay with that because I trust my spouse and I'm not worried about it. But what it does for us is that if I did become incapacitated, and I find this a lot with older adults, someone might be really struggling and the family comes in and they say, mom's been really struggling. We need to have her determined incapacitated, but we can't get any doctor to do that. We have to make an appointment because he hasn't seen her in 6 months. And so we can't get in for 3 weeks, but we need someone to act now. What do we do? And, what do we do? Well, we try and get the doctor to see us earlier. But if you make it effective immediately, it avoids having to have that incapacity determination. Now, sometimes clients will say, well, you know what? I don't want anyone to be able to do anything unless I can't do it for myself. And so then we would make it effective only when they are incapacitated. And then there's this hybrid model. And the hybrid model is oftentimes I see it with spouse effective immediately, but if anyone else is asking, maybe adult children are named as backup to a spouse, sometimes we'll say, you know what, they can't act unless I am incapacitated. So that would be a hybrid. And so it brings me to just a little point. If you have a durable power of attorney and you ask yourself right now, boy, when is mine effective? And you don't know that answer, then you should probably go home and dig it out and understand when it is effective. And I do recommend that you give your power of attorney to all of your financial entities. So you should be taking it to the bank. You should take it to your investment advisor. If you have life insurance, you should be sending it to them. All of those entities should have a copy of that, and you should ask them to confirm that they accept it. Because what if, we sent the powers of attorney, again, I'm driving home, I'm incapacitated, my husband now needs to, let's say, do something with my life insurance policy that's in my name. Maybe we're going to cash it out to help pay for my care. And he calls them and he says, oh, hey, we sent you that power of attorney a long time ago. And they say, oh, yeah, well, let's say he didn't send it. And they say, well, send us a power of attorney. Let us review it. And they review it and they say, well, it doesn't have this language in it, so we're not going to accept it. And now I'm incapacitated. I can't sign a new one. And this life insurance company is not going to work with my husband. And he's going to have to go to court to get an order to force that insurance company to deal with him. So I encourage my clients to take those powers of attorney to all their financial institutions now, get confirmation that they have been approved by those entities, because I don't want to find out 10 years from now that they don't like number 7 and they're not going to accept it. The last thing I wanted to say about powers of attorney is they can be very narrow in scope or very broad in scope. And what I mean by that, an example of a very narrow in scope power of attorney would be for a real estate transaction. Maybe my husband and I owned a property in Florida and we no longer go to Florida, so we're selling that home. We may create a power of attorney that gives our realtor in Florida the ability to just sign real estate documents for us. So that power of attorney is very narrow in scope. Because I work with a lot of older adults, I try and make them very broad because I want to make sure that I'm covering every scenario under which someone might need to do something for someone. I want to try and capture every scenario where someone might need to use that power of attorney. So they're very, very broad in scope. And so when I'm working with clients, I'm trying to get to know them, trying to understand who their family is, trying to understand who they've appointed to act on their behalf, so we can make sure that all of the right powers are in that power of attorney. And that includes things like being able to sell real estate, being able to do banking, being able to take required minimum distributions if you are at the age where you're taking those out of your retirement. A lot of my clients are looking at long-term care. And so can they do the things that you might need to do in order to qualify for a long-term care benefit? Those are very specific powers. And sometimes I will have clients who come in and they need long-term care, and maybe we need to move assets from that person and gift them to a spouse. A lot of times powers of attorney don't have gifting in them. And if I can't give them to a spouse, we might not be able to get someone qualified, for example, for a Medicaid benefit. So the second thing I would say to you, if you're sitting here and the first question you ask yourself is, when was my power of attorney? When did it become effective? And you don't know that answer, go home and figure that out. But you should read your power of attorney and understand, what powers have I given to my agent? And it's not a bad idea if you haven't looked at it in a while and you're updating it with your attorney to really have them explain what powers you have in the power of attorney. The other point I would bring up is that in the gifting, because gifting is very important, especially for older adults if you need to qualify for Medicaid. I often see gifting powers that say you can gift up to the IRS limit. Has everyone heard that? Oh, the IRS says I can give this much money. Is that familiar to everyone? Sometimes I'll see gifting in that regard, that my agent can make gifts that shall not exceed the annual federal estate tax exclusion amount. Well, currently, does anyone know what that amount is? Close? $19,000. So if I have, let's say, a $100,000 IRA, and I need to qualify for Medicaid because I need to be in a nursing home, and my husband needs to keep that IRA, which he would be allowed to do under Medicaid rules to help him survive in his home, living at home still, and he's only allowed to gift himself $19,000, I'm not going to be able to qualify for Medicaid, and he's not going to be able to keep my IRA. So gifting is a really important thing. So I would encourage anyone to go and look and make sure you have gifting powers in your power of attorney. Okay.
Friends, there's a question online. It says, is it standard to have a durable power of attorney and be a conservator along with an MPOA?
Medical power of attorney. So usually if you have a financial power of attorney, you're not going to also be a conservator, because a conservator is what happens if you don't have a power of attorney, or if for some reason maybe you have a power of attorney and you've named Bob and Joe are incapacitated, or Bob and Joe are dead, or Bob and Joe are criminals, or Bob and Joe are not able or willing to serve. In that case, you really got no one to act under your power of attorney. And even though you have a power of attorney, you're going to have to go to court to become a conservator. So usually you have one or the other. And most of the time in court, because I do a lot of conservatorships, if we have a power of attorney and the court appoints a conservator, most of the time the court is going to put in the order that all powers of attorney are now suspended, that they're no longer valid. So it's usually one or the other, not both. Yeah. Okay. I'm going to move on to patient advocates, which is that medical power of attorney. Unlike the durable power of attorney, which can be effective immediately, in Michigan, your power of attorney can only be effective if you are incapacitated. So what a medical power of attorney does is it allows you to appoint someone to make health, welfare, and well-being decisions for you. Some people think it's that pull the plug document, but it's much broader than that. It does include in it, in Michigan, we don't have a living will. So a lot of people say, oh, I need a living will. Michigan does not recognize a standalone living will document. Michigan will recognize a living will document if it is in a patient advocate designation. The living will language is the language that allows your patient advocate to remove life support under certain circumstances. So it's the portion of the document that says, I authorize my patient advocate to remove artificial support if the doctors make certain decisions. But where I see patient advocates used much more often is if someone needs to go into long-term care. The people at assisted living communities, the people at nursing homes, they want to know who's that decision maker. If that person falls out of bed, who's the person we're going to call to get authorization to take them to the hospital? If I'm in the hospital, who's going to be the person who's authorized to sign discharge papers to allow me to go wherever my next step is. Who's going to authorize someone to treat me for my UTI or whatever it is that I have? That's where we see those documents. And I'm a big proponent that the minute you turn 18, you should have a medical power of attorney or patient advocate designation. I go to court almost once a year for a young adult, usually a young man, who takes some risky behavior and becomes incapacitated. And the parents are always a little surprised when they're not allowed to make decisions on behalf of their 18-year-old child or 20-year-old child, because they're thinking, this child still lives at home, I still pay all the bills, I still insure them, I take care of them. What do you mean I can't make decisions for them? And the court is going to say, well, how do we know that John wants you to make the decisions? And so the court is not going to allow you to do that. And so we have to get the court version of that is a guardian. So a conservator handles money, a guardian handles health, welfare, and well-being. And so a lot of times for my clients who are adults, regular adults, older adults, if they don't have a patient advocate designation and they become incapacitated, someone is going to have to go to court and get appointed to do that, just like we did with the conservator. That patient advocate designation allows someone also to be able to make treatment decisions, medication decisions, organ donation. So all of that can be included in that document. And that's a really important document to have. And again, if the people that you've named are no longer able or willing or around, then if you don't have someone actively able to name, then it's like not having that document at all. So you should look at that and make sure that the people that you've named are still willing to do that.
I have a question. Of course, if we have single adult males.
Yeah, I've got one of those. I know. Every time he leaves the house, I'm like, please.
It would start with mom, dad. How, on that document, how far down, how many can you succession list?
There's no limit. I mean, you could have the deepest bench in the world if you want, but I would recommend, I like at least 2, if not 3, because you don't know if someone, if you name A and A can't do it, then we get to B, C, D. So, you definitely can have a very deep bench.
Okay.
So I will say that in Michigan, we don't really have any clear guidance on whether or not you can have co-patient advocates. A lot of times my clients, especially if they have 2 children, they'll say, well, can I name both of them? And we can, but then we also put in language that says if the state of Michigan doesn't recognize patient advocates, then it's this one, then this one. Unlike a durable power of attorney where you can clearly name co-agents. I will tell you, I'm not a giant fan of that because banks are generally not a giant fan when you name 2 people to be your agent under your power of attorney, because what banks don't like is if you name, I'll just use my 2 oldest kids, so Chloe and Mallory as my co-agents under my power of attorney, and Chloe goes to Chase Bank and says, I need to take $10,000 out of mom's account to help pay for whatever. And the bank says, well, where's Mallory? And the durable power of attorney might specifically say that my agent is able to act independently. Banks sometimes don't care about that because they're worried, well, I don't want Mallory to come back and say, hey, I didn't agree to that. So banks are not super crazy about co-agents. So if my clients want to name co-agents, then I'm really encouraging them to go to the bank with that document and say, hey, I've named Chloe and Mallory. Will you please confirm that Chloe and Mallory don't need to be in the same room at the same time to make a decision? That if Chloe does it, she's fine doing it by herself. Just because, again, I don't want Chloe and Mallory to have to wait and they're really not doing anything because I don't need them to. And all of a sudden I'm incapacitated and Chloe goes to the bank and they shut her down. So you can, but we like to do it and make sure that it's going to be okay. Okay? All right. So now we're going to move on to death. We're getting to the death documents here. So last will and testament, which is really just your will. And I'm just going to out of the gate say, oftentimes people will say, I don't need to worry about probate. I've got a will. And I've got bad news. The only one who cares about your will is the probate court. Nobody else cares, just the probate court. So when you have a will is a set of instructions for the probate court. If you have a bank account, for example, just in your name, so if I have the Catherine Jacobs bank account and I die, and my will says I leave everything to my spouse, and my spouse doesn't survive me, to my 4 children equally, and I die with this account just in my name, and my husband's not a joint owner, and I didn't put any beneficiaries on it, but my will says spouse then children, my husband could not march up to Chase Bank with my will and say, oh gosh, horrible, tragic, horrible, horrible news. Catherine's gone. If in between sobbing, he would do that, I think, right? No. And he would say, am I the beneficiary? And they would say, no, Catherine didn't put you on the account. And then he'd probably stop sobbing. But then he would say, well, good news, I have her will, and her will says I'm the beneficiary. And it also says I'm the executor. So here you go. Well, Chase Bank is going to say, well, we don't care. Go to the court and take that to the court and come back to us when you have a document that shows court authority. So I'm going to recap that in a different way to say it another way. So a will is in charge of assets that don't naturally pass to someone. And what I mean by naturally pass to someone, if that bank account was a Catherine and Ken Jacobs account and Catherine died, it naturally would pass to Ken because we're joint owners. The will wouldn't matter. My will could say, I leave everything to my Rotary friend Katie, but if that joint account was with Ken, the will doesn't matter because it's a joint account and it's going to go to Ken. If I had an IRA and my IRA said beneficiary Ken, contingent beneficiaries children, that is naturally going to pass to them because I have beneficiaries on that account. If I had a life insurance policy with no beneficiary named, then it's going to have to go through my will. So when you name a beneficiary or you have a joint owner, that is naturally going to pass to the people named. That includes if you have a trust and the asset is in the trust or the trust is the beneficiary, it is naturally going to pass to the trust. So the will is only in charge of those assets that don't have a beneficiary or a joint owner. And where I see that most often is in homes. Ken and Catherine Jacobs own a home. Catherine dies. Now it's just Ken's asset. And Ken doesn't do anything with that to either put it in a trust or do something called a ladybird deed. And then Ken dies, and now this home doesn't have any other joint owner. That home is going to go through probate. And that is when a will is going to be in charge. So a will is only in charge of assets that don't have a joint owner or a beneficiary. And when that happens, then someone has to go to the probate court and ask the court to become the executor, which in Michigan we call the personal representative. And then that personal representative is going to look at the will to figure out, what am I supposed to do? Because remember, it's an emergency. Emergency is Catherine's dead. And the will tells us who's in charge, Ken. And what is Ken supposed to do? Give everything to himself. Unless he wasn't alive, then it would be my next person in charge. And what would it say? Give it to my children. And so that's what a will does. Okay. Questions about probate? I will say probate, one of the things that I don't love about probate is that it's a very public event. And what I mean by that is if I died and my husband Ken went to the probate court, took my will because I had a couple, let's say that I had a life insurance policy with no beneficiary, and let's say it was a $500,000 death benefit. And let's say that my mom left me our cottage, and that cottage was worth $300,000, and I didn't put it in someone else's name. So now I've got a $500,000 life insurance policy and a $300,000 cottage. So I've got $800,000 in assets. And so he is going to have to file this. When he files that probate petition, he has to disclose who are the interested parties. So it's going to be him and it's going to be my children, and all of their addresses are going to be on this public document. And anyone can go in and look at public documents. So people will find out who my heirs are and where they live. Then my husband, under the law, 91 days after he's been appointed as my personal representative, is going to have to file something called an inventory. And on that inventory, he's going to list that I had that $500,000 life insurance policy and that cottage. And so now it's public that I had $800,000 going through probate and who my beneficiaries are. Now, where I get concerned about this is if I have a 90-year-old or a 95-year-old client who dies and they've got 3 children who are in their 70s, now we've got predators who very much like to prey on older adults, and they will see, oh, we've got this 95-year-old person who died with these 70-year-old beneficiaries who are all going to inherit this money, and we know their addresses, and we can go on this Google thing and probably find out a lot of information about them, and what are the chances that maybe we could scam them? Let's try, right? So it's all public information, and that is what I don't like about probate. And as a probate bar, we have not figured out how to get around that, because probate is meant to be public, so that if you are a creditor of someone's estate, you have the information that they've died, and if they owe you money, that is how you get it. So we really want to avoid probate when we can. And so when I'm meeting with clients and we're talking about, will a will work for you? Will a trust work for you? How will things work? And sometimes people say, I don't want a trust. That's too cumbersome. I really don't want that. I just want to do a will. Then my goal is to figure out, okay, how can we give you your will? Because it's a safety net document, right? It's going to tell us what to do with that bank account or with that house, with that asset that doesn't naturally go to someone. It's our document that will give us our instructions. But I'm going to do a really good job of working with my clients to say, okay, let's make a very detailed list of all of your assets. And let's make a chart and say, okay, you've got a bank account at PNC. Do we have a beneficiary on that account? You've got a life insurance policy. Let's confirm that we've got beneficiaries. You've got retirement accounts. Let's confirm there are beneficiaries. You own a home. Let's do a ladybird deed. Let's make sure that when we go to bed tonight, if we don't wake up, we know every asset is going to naturally land in someone's lap. Okay? So you don't necessarily need a trust, but you definitely need a will as that safety net. But you definitely need to do the back end. And we're going to talk more about the back end in a little bit. So I'm going to transition off wills unless questions about wills. Okay.
And with the ladybird dates, I thought those were, you couldn't do those anymore.
Well, no one told me. No, just kidding. No. Yeah, no, I did 3 today. Yeah, no, we use ladybird deeds all the time. So let's talk about ladybird deeds. What is a ladybird deed? So it doesn't say on it ladybird deed. So sometimes I'll have a signing conference with clients and we're doing a ladybird deed and they'll say, well, wait, where's my ladybird deed? It doesn't say that. And the other day I had someone call it a ladybug deed, which I really enjoyed. And I also had someone call it a lily pad deed. So those are near and dear to my heart. But what is a ladybird deed? This is how the language would read very simply. And I'll just use myself again as an example. Ken and Catherine Jacobs deed their home to Ken and Catherine Jacobs for their life. And during their life, they're the complete owners. They can sell it, they can lease it, they can mortgage it, they can paint it purple. They can do whatever they want to their home. But the minute the survivor of them dies, it transfers to X. And X could be their children, X could be their trust. And so a ladybird deed is really a way to put a beneficiary on your home. There are many states that have what we call transfer on death deeds. Michigan has tried several times to introduce and pass legislation to pass a transfer on death deed act, but we haven't done that. So the ladybird deed is actually found in something called the Michigan Land Title Standards 9.3. And in that Land Title Standards Act, it spells out that you can do this ladybird deed, that you can what you're essentially doing is granting yourself the right to own it during your life. But the minute you die, it goes somewhere else. Now, ladybird deeds, I will tell you, during COVID, interest rates went so low during COVID, and everyone was refinancing their house. And people would go to the mortgage company and they'd say, oh my gosh, I want this 2% interest rate. And the bank would the mortgage company would pull up their deed and see that they had a ladybird deed. And banks don't like ladybird deeds. So we had to undo the ladybird deed, which is just another deed saying this deed terminates the ladybird deed. And then they could get their refinance, and then we would redo the ladybird deed. But the ladybird deed is alive and well, thankfully, and it is a great way to avoid probate. We use those a lot for people who are on Medicaid. So clients who need long-term care, whether they're in a nursing home or they're getting My Choice waiver benefits in their home, who are on Medicaid. In Medicaid, there are certain assets that you're allowed to keep. You're allowed to keep a car and you're allowed to keep a home. But in the state of Michigan, we have something called the Estate Recovery Act, which means when you die, if anything goes through probate, bank account, life insurance, home, if you have to open that probate estate because something didn't naturally flow, then the state of Michigan has the right to put a claim against your estate to recover any money that they've paid on your behalf for Medicaid. And so often I said to you, where do I see probate the most? It's in a home, right? Ken and Catherine own it. Catherine dies. Ken owns it alone. Ken applies for Medicaid. Ken can keep the house and get Medicaid, but he hasn't done a ladybird deed. When he dies, no beneficiary on that house. It's going to go through probate. The state of Michigan is going to be able to come in and say to my children, hey, sorry, we get first bite of this apple, and you kids can get anything that's left over. And so it's a very simple, when we're doing Medicaid applications, we're always, as a matter of course, if the person is keeping a home, doing a ladybird deed, so that'll avoid probate. Okay. I was going to say one other thing about a ladybird deed. Oh, this is what I was going to say. So I have a couple of my own personal rules about ladybird deeds. And as a mother of 4, I would not do a ladybird deed to my children because there's 4 of them. And although, thank goodness, they get along very well, a ladybird deed would say, in my scenario, Catherine Jacobs deeds the house to Catherine Jacobs for her life, and during her life she can own it, sell it, lease it, mortgage it, but when she dies, it goes to her 4 children. So when I die, thank goodness, we're going to avoid probate, but now my 4 children own this home together. And we have a lot of headstrong children. So now they all have to agree who's going to list the home, who is going to choose the how much we're going to sell it for. We get an offer, they all have to accept it. So they all have to sign the listing, they all have to sign the sales agreement, and they all have to agree. And this is where I see all of the baggage come out, and sometimes, I'm sorry to say it, it's the in-laws. Why does your brother always have to be in charge? How come he gets to pick the realtor? That's not enough money. All these little things. And so I don't ever want to put my clients' children in a position where we might create conflict. As a mother, I would be so upset to know that a plan that I put in place caused a family to fracture. And so when we have more than a couple kids, my hard and fast rule is generally we'll create a trust just to hold that home. And so now the ladybird deed is going to read, Catherine Jacobs deeds the house to Catherine Jacobs for her life. She owns it, sell it, lease it, mortgage it. But the minute she dies, it transfers to her trust. And in my trust, I'm going to have who's in charge and what they're supposed to do. And so if I named, for example, my oldest child, Chloe, to be my trustee, then Chloe knows she's the one who's going to pick the realtor. She's the one who's going to sign the listing agreement. She's the one who's going to talk with the agent about what we're going to sell it for. And she's going to sign all the closing documents. She's going to get the money and she's going to distribute it. and we don't have to get everyone else involved. So your ladybird deed can name individuals or it can name a trust. And so my hard and fast rule is you got more than 2 kids, ladybird or a trust for you, just for that purpose. So that kind of will move us into trust if we're okay to move on. And thank you so much for that question, because I really did want to talk about ladybird deeds because they are a really important tool. I find that, for a lot of people, that is a really good planning tool for them to have until Michigan adopts a transfer on death deed. But I don't see that happening anytime soon. So what is a trust? I always like to use the analogy that a trust is like a box. You've built a box to hold your assets. And I did say, that these are sort of the death documents, but a trust really is a hybrid of a document that you use while you're alive. That's why we call it a revocable living trust usually, and also when you're gone. So you've built this box, and the actual trust document is the rule book for the box. It tells us who's in charge while you're alive. It tells us who's in charge if you're incapacitated. It tells us who's in charge when you're gone. And it tells us what to do with those assets. So oftentimes, well, not oftentimes, when you create a trust, you generally wear 3 hats. You are the settler, which means you are the person who set it up. You also are the lifetime beneficiary usually. You say, you know what? Anything that's in this box is for me to use while I'm alive. My bank accounts, my home, whatever's in that box, it's yours. So you are the beneficiary. You also are the trustee of the trust usually. Most people make themselves the trustee, which means you're sort of the CEO of the box. I'm in charge of what goes in, what goes out, who gets it, when you get it. And does anyone in here have a trust that wants to admit it? Okay. So usually, I would love your answer to this, that when you have a trust, you really don't even notice that you have a trust. You don't file a trust tax return. You don't have to prove you're the trustee of the trust. You just go about your business like a normal thing. This box is in the background. You really don't think about it. And it's really just that box to hold your assets. Now, some assets while you're alive might be in your box. Some assets, if your home, for example, was in a ladybird deed that transferred to your trust at your death, if you imagine that box, if this is the Catherine Jacobs Trust, and we have a ladybird deed, that it doesn't go into the trust until I die, then my house is really hovering above my box. And the minute I die, boom, it falls into the box. And then the box is in charge. So a lot of times assets might be in the box. They might be above the box. They might be not in the box at all. And we'll talk about that. So I'll bring it up. So sometimes, for example, I'll have clients and maybe their assets are a home. They have bank accounts, life insurance policies, and retirement accounts. Very, standard set of assets that most of us have. So we might have the bank accounts in the trust. We might have changed those accounts to be trust accounts. We might have the life insurance policy named as the beneficiary, so it's hovering above the box. And we might have a ladybird deed, so that's also hovering above the box. With retirement accounts, because of the way retirement accounts are taxed, we usually never put those into a trust. So they're not even in the box and they're not hovering above the box. They're over here. And that's part of when you're doing estate planning, figuring out where everything fits in. So I sort of went off trust. I'll come back to retirement accounts and taxes. But with a trust, it allows us to put up guardrails. So a trust does a couple things. One is it avoids probate. So if things fall into the box, we don't use the will, we don't look at the will, we don't need the will because the trust is our set of instructions. And so it avoids probate. The other purpose of a will is that it sets guardrails. So if I have clients who have minor children, more often than not, I'm recommending a trust. And the reason I'm recommending a trust is because if that trust, for example, and I'll give you a real life example. I have a client and it's actually a guardian and conservator for a young man who is now 17, but at the time that his mother passed, he was 14. His father had passed when he was an infant. Mother got cancer. She knew she had cancer. She knew she wasn't going to survive. She had a life insurance policy, and someone said, oh, you need to name your child as the beneficiary so that when you die, you avoid probate. And it did exactly the opposite of that. We have been in so much probate. My head spins at how much probate, because a life insurance company is not going to write a check, in this case, for $300,000 to a minor child. And so we had to go to the probate court and get a conservator appointed for this minor child so that the conservator would be in charge of that money. And the court said, we don't know this family. We don't know who you are. And we're giving you control of this money that's meant to be for this young man. And so because we don't know you, we're going to put this money in a restricted account. And you cannot use this money until you come to the court. So every time you need money for this young man, you have to come to the court and petition them, which is a pain in the rear, But also, it's protection for that young man, right? And the other thing that's going to happen is when this young man turns 18, because it's not in a trust and there's no restrictions on it, at 18, they're going to hand him this $300,000. The house that his mother owned also is going to transfer to him, probably at this point, a $600,000 home. This young man is going to turn 18 and have almost $1 million. And I don't know about you, I have 4 kids right now, 20 to 28. And if $1 million landed in any of their laps at this point, I don't know that they would make the best decisions with that money. That's a lot of pressure on a young person. And if that mother had gotten better advice, and my heart breaks, because just simple advice to say, let's set up a trust. Let's put some guardrails in place for this young man. Let's have the home and the life insurance policy flow through this trust. So when this happens, this young man is going to have this money. We're not going to have to go to court. We're not going to have to get a conservator, which, by the way, we also have to file an annual accounting every year. We have to have a hearing. The court has to review it and make sure it's okay, which is good because it protects it, but it's a lot of rigmarole. But it could say, we're going to hold this money in this trust for this young man, make sure we pay for school, make sure that he's got a vehicle, make sure that he's got all the things that he needs, and maybe we're going to hold it, and when he's 25, we can distribute it out, or maybe some of it at 25. A trust could have set up those guardrails for him. So, Elizabeth?
So every time you go to court, you have to pay? You're paying?
Well, it's a $20 petition fee, and, certainly they've asked me to help them, so there are legal fees, and so...
And every year, so there's no legal fees. So
Yeah. Luckily, they have done a really good job investing, and we barely touched the money, and the family's really helping this young man out, but that's not always the case. And so it was very bad advice, whoever told that person to put this child. So a trust is, when I have minor children, I'm almost always recommending that we set up a trust for minor children so that until they get to a certain age. And so, as I mentioned, my children are 20 to 27. So in a couple of years, when our youngest gets a little bit older, we may consider that we don't really need a trust anymore, that we could just name our children as beneficiaries on our accounts and not have to worry about it going through a trust to get to them. But, our youngest is still 20, and any kind of $100 to her would be gone. So let alone any significant money. So we still have a trust, but a trust also is really important for beneficiaries who maybe are struggling. Maybe I'm talking with clients and they mention, well, our daughter has a substance abuse problem, or our son's in a really bad marriage and, divorce is on the table every other month, or we have someone who's got special needs. If you have special needs and you're getting a public benefit, if you inherit money, that could disqualify you from your benefits. And so we can create a trust for them so that any share, we don't have to disinherit them, but we can say, hey, any share for Sue can go into her special trust, and that trust can hold it and make sure that she has the best life possible with that extra money available to her. So a trust is really great for those special circumstances when we have beneficiaries who are struggling or have different challenges in their life. A trust really allows us a lot of flexibility in that regard. So questions about trusts? Yeah.
So you know when you're going to buy a house from a family member,
Yeah,
that tax credit can stay low.
the uncapping, yeah.
Yes. How does the trust process affect that?
Yep.
Good question. Look at that. I like that. So in Michigan, what he's talking about is if, for example, I own a home and when I die, it goes to my children. The property taxes, when you get your property assessment, you get your assessed value and your taxable value. So I'm going to go back a little bit. So let's just say, I got to write my numbers down so I don't forget them. Let's say that my taxable value is $100,000, but my assessed value is $300,000. That means that my house is supposedly worth $600 because 2 times your assessed value is what it's supposed to be. But my taxable value is only $100,000. That's what I pay taxes on. Your assessed value can go up any arbitrary number. If the market's doing really great, it could go up, 20%. If the market's doing really bad, it could fall, but it has no restrictions. Your taxable value can only go up based on the consumer price index or the rate of inflation, and it's capped at 5%. So this year, I think it was 2.7%. Last year, I think it was 3.1%. So when you buy your home, so if I bought your home from you, third party, and you sold it to me for $200,000 in 2026, when I get my 2027 assessment, it's going to show a $200,000 taxable value and a $200,000 assessed value. The following year, I still own it now. And they're going to say, wow, this neighborhood, Catherine moved in, things jumped. And now my house, my assessed value is $300,000 instead of $200,000. But my taxable value is only going to go up that small percentage. So you'll see over time where when you buy a home, they're equal, your assessed value continues to go up and the taxable value is slow. So what he's talking about is when you inherit property, do you get that uncapping? Because when I bought it from him, his assessed value, we kind of got different numbers, but his assessed value was 300, his taxable value was 1. If I bought it from him, it would jump up to the 300, to the sales price, half of the sales price. It uncaps, your tax is uncapped. If you have a trust, so if my trust says I leave my house to, what's your name? John. Thank you, John. I love John now. I'm going to leave my house to John. My property is going to uncap because you are not a family member. If I left my home to my daughter, Chloe, it would not uncap, and it can come from a trust. So there are certain familial rules about uncapping, and as long as your trust transfers to a family member who is down a line and not outside, so no cousins, no aunts, no uncles, no nieces, no nephews, but children, grandchildren, parents, grandparents, no uncapping. So that's a great question to lead into this. Sometimes I'll be planning with people and they'll say, hey, we really want to leave our house to our daughter and our son-in-law. Our son-in-law is the best guy ever. We don't know how he puts up with that gal, so he deserves that house. Please put in the trust everything to daughter and son-in-law. I will not, well, I shouldn't say I will not do that. I will do that, but I will advise them that we are going to have a 50% uncapping of the taxes because son-in-law doesn't get that exclusion. So we will have an uncapping. And so what I'll tell them is, let's just leave it to daughter, and the trust can transfer it to the daughter. A spouse can transfer to a spouse without uncapping. So it's a 2-step process. So when I die, goes to the daughter, no uncapping. Daughter then adds husband to the deed, no uncapping. Okay? Which also, so if we're talking about real estate, let's stay on that for a minute. This concept of, I want to add someone to my deed. People, especially little old ladies, we love to add our kids to our deed. Anyone have a thought as to why we like to do that? Because it avoids probate. And they don't want to go through probate. And I don't blame them because we just talked about how bad probate is. So they come in and they'll say, boy, I don't want my deed to go through, my house to go through probate. I want to add my kids to my deed. And I'm going to do my darndest to talk them out of that for a lot of reasons. And here's why. Number one, if I add Chloe and Mallory to my deed, and Chloe marries this lovely young man, and then it goes south and they get a divorce, because she owns part of my home, my home is part of her marital assets that are now part of her divorce. If I add my daughter Mallory and she's got bad credit and the creditors come after her and they get a judgment, part of her assets are my home, because when you add someone to your home, they're an owner. And so now her creditors have the ability to come after my home. If I add Chloe and Mallory to the deed and they stay on the straight and narrow, we don't have to worry about all these other things, and I die, let's say when I bought the home, I bought it for $100,000. Let's say when I die, it's worth $600,000. If I add them to the deed before I die as owners, their basis becomes my basis, which means their basis is $100,000. So if they sell that home for $500,000, they have $400,000 of gain that they're going to have to recognize. Whereas if they inherited it through my trust or through a ladybird deed, they get what's called a step up in basis. And so instead of getting a $100,000 basis, they get the basis as of the date of death, so $500,000. So if they sell it, they're not going to have any capital gains. So when you add people to a deed, you could really be creating a very bad tax situation for them. So there is generally no circumstance where I can think of where it really makes sense to add someone to your deed that isn't a spouse, for example. So questions on that?
So with the ladybird deed, that when you were talking about the capital gains,
Yeah.
ladybird deed, that would
Trigger that you get a step up in basis. Yep.
Get the step up.
Yep. So if it said, for example, Ken and Catherine Jacobs for their life, and when they die to their daughter Chloe, Chloe gets it at our death, and her basis is whatever the value is as of date of death. So if she kept it for, let's say it was $500,000 when she got it, and she kept it for a couple years, and now it's worth $700,000, she would only recognize $200,000 in gain. And if it's her primary residence, you get some exclusions, so she might not have any gain. But yeah, so you really create some bad situations. I will tell you, and I'm allowed to share this story, one of the first cases that I handled when I got out of law school was with my mother-in-law. And my father-in-law died at 59 unexpectedly, and my mother-in-law worked in a mortgage department, and her very helpful friend said, "Oh my gosh, Terry, you better put your kids on that deed. What if something happens to you? You don't want it to go through probate." And so within 10 days of my father-in-law's death, she had executed a deed transferring the property, adding my husband, my brother-in-law, and their stepsister to the deed. And fast forward 10 years later, my husband and I are now married. We weren't married at the time. Now we're married. I'm just graduating law school. She decides she wants to retire and she's going to sell her home and buy a condo. And the realtor comes out and sees this deed that adds the 3 kids and says, "Oh, you have to get the boys and your stepdaughter to sign the listing agreement." She says, "Oh, okay, no problem." And so she contacts the boys and they say, "Oh, sure, Mom, yeah, we'll sign that." Stepdaughter says, "Oh, I'll sign it, but I want my 25%. And at the time, there was a case that allowed us to get around it, but that case has now been overturned. And today, she would have to give 25% of that home to her stepdaughter because her stepdaughter was an owner. And so you just don't know. And, you can't just, if you add someone to the deed, if I put my kids on the deed, I can't take them off. They have to take themselves off. They have to deed it back to me. I can't control that. I've given up ownership. So I will just tell you, deeds are tricky. Friends don't let friends that aren't attorneys do deeds. I'm just going to say that. I'm just going to give you another little horror story. I met with a gentleman who came in. His mom had a trust, and the trust had a cottage. Cottage was worth about $700,000. It says, when I die, the cottage goes to Bill and Mike. And Bill is the trustee of the trust. So Bill drafts his own deed saying Bill as trustee deeds the house to Bill and Mike. And that's all it says, just Bill and Mike, okay? Mike dies. Mike's spouse says, oh, sweet, now I own half this cottage. And Bill says, oh, no. See, the trust says it's supposed to go to me and my brother. And if one of us dies, it goes to the other. Well, that's what the trust said. But the way he did the deed, because he didn't specify that it was joint tenants with rights of survivorship or joint tenants, in Michigan, if you don't specify the type of deed, it defaults to something called a tenants in common deed. And a tenants in common deeds means when you die, your share goes to your heirs. So Mike's spouse got half of that cottage. And so because this gentleman didn't, pay some attorney a few $100s or even $1,000 to help him with the deed, he lost $350,000. So it's not worth it. There's so much litigation about deeds. I just would caution anyone to not do a deed on your own, because they can be tricky. So, yeah. Yeah, no, sure.
No, the attorney that you're talking with is broadly based enough to cover all those things and not giving you bad information.
Yeah, that is a good question. I'm going to have to think on that one. Certainly, looking at how long they've practiced and what their practice is, if you're going to someone who is doing real estate for you or estate planning, that should be their lane. Most attorneys, we don't, there's very few of us anymore who are general practitioners. We really much specialize in an area. I specialize in estate planning and elder law that encompasses, guardianships and special needs planning. But if you came to me and said, hey, we need to file bankruptcy, or, our son got a DUI, I couldn't help you. Or I want to get a divorce, I can't help you, because I don't know that law. You might as well do it yourself. That's how much I don't know that law, because it's so specialized in nowadays. So if they do that a lot, I think you'll be fine. So I did want to talk about, so in the back, I did talk about deeds a little bit. I just want to make sure I got everything. Oh, asset titling. The devil is in the details with estate planning. You might have the most wonderfully written estate plan documents, but if you don't take the time to make sure that all your assets align with your estate plan, it's going to implode. And what do I mean by that? I'll give you an example. I had a client come to see me. Her mom had done an estate plan, and in her will, she just had a will, and the will said, I leave everything equally to my 3 children. And she had one bank account, and the bank account had $100,000 in it, and the bank account named the daughter as the beneficiary. The 2 sons lived in California, and the reason the bank account had the daughter as the beneficiary is because she was here in Grand Rapids, and she would take mom to the bank, and the bank lady said, hey, we're going to put you on the account, and we'll make you the beneficiary. That way, when everything's gone, you can take care of it. Well, then she died, and her position was, hey, I'm the beneficiary of this account. I don't care what mom's will says. I don't care that mom's will says I'm supposed to give it to my brothers. They're never here. I've done all the hard work. And she was right. She was a beneficiary designation overrides a will every day of the week. So if that beneficiary designation said daughter only, those boys have no claim to it. So you really have to make sure that your beneficiary designations align with your estate plan. I want to talk quickly about long-term care planning. Most people don't talk about long-term care planning until it's a crisis. Someone's in the hospital, they've fallen, they've broken a hip, and now all of a sudden they're being talked to about discharge, and we're going to discharge your person in 3 days. Where do you want them to go? What do you have set up? What estate planning do you have? Where's your power of attorney? Where's your patient advocate? A lot comes flying at you. It is overwhelming. I like to say that sometimes getting old is like a gut punch. And we talk about planning for retirement, and when everyone talks about planning for retirement, they're talking about saving money. Make sure you've got your nest egg. But really, we should be talking about aging, because it is a very, very big topic, and we don't plan for it, and there's a lot of missteps. I spend a lot of time undoing things that people have done that put them in a bad position. For example, gifting. People love to give gifts to their children, and we talked about that $19,000. The IRS says you can give $19,000 away to a person. Well, I'm just going to break the bad news to you. That rule is for really, really rich people. And what I mean by that is when you die, so if I died this year in 2026, the government says, Catherine, you can die this year, and the good news for you is the first $15 million of your estate is not taxable. But everything over that, we're going to tax, which, lucky for me, I guess I don't have that kind of money. But if I did, anything over 15 million would be taxed. But what they're going to do is they're going to say, but Catherine, did you give any gifts away? So they're going to look back and say, did you give 100,000? Did you do this? Did you do that? If I gave that $19,000 away, I don't have to report it. It has nothing to do with paying taxes. I can give $19,000 to each of my children this year, and I don't have to report it. If I give them $20,000, I am supposed to report that. Why? Because at my death, the government is going to say, how many gift tax returns did Catherine file? And let's say I was very philanthropic with my $15 million. And let's say I gave a lot of gifts. They're going to look back at all those gifts and say, wow, during Catherine's lifetime, she gave away $5 million. She filed those gift tax returns. I didn't have to pay taxes on that. I just had to file it. I had to notify them. They're going to add that back in. So if I die with 15 million, but I gave away 5 million, they're going to say you died with 20 million, and they're going to tax me on that 5 million. So this $19,000 and not paying taxes, for most of us, it's not even an issue. Don't worry about it. But while the IRS is worried about these gifts and gift tax returns, who cares about that $19,000? Medicaid. And so my clients will say to me, when we're doing, a Medicaid application for them, and I'll say, have you given away any money, including, this is where I always see it, grandma doesn't drive anymore. She's got her nice little sedan, and we gave it to the college kid who needs a car. That is a gift, and that's a divestment, and Medicaid's going to penalize you for it. I had to loan my son 10 grand because he needed an attorney for his divorce. That's a gift, and it's a penalty, and you're going to have to pay for the penalty. I just gave gifts to my kids, the 19,000. The IRS says I can. That's a gift. It's going to be a penalty. So we have to be very careful about gifting assets, and that means selling an asset for less than fair market value. It means giving a gift. It means giving gifts to charity. Now, if you have a pattern of giving to your church, I just had a Medicaid application approved, and these people had always given money to their church. And we signed an affidavit that this is consistent with the giving that we've always done. Medicaid will overlook that. But I did have an application where right before we filed the application, before they came to meet with me, they gave $50,000 to their church for a capital campaign. That's a gift. That's a divestment. That's a penalty. So you have to be very careful, because if you're applying for Medicaid, they're going to look back 5 years. And so, as you're doing your estate planning, if you are over 60, I would say that is a good time to start at least exploring, what might be some of the issues involved with a planning for long-term care. And I'm not going to get too far into it, but just to put that out there. Yeah.
I have another question.
Okay.
In regards to trust. Is it common for spouses to have separate trusts, or is there a reason that a spouse would have a separate trust?
Yep. It was very common for people to have separate trusts in the early, before 2000, in the early 2000s. Most of the time, spouses had separate trusts. Why? Because the federal estate tax limit was so low. So it used to be about $600,000. So spouses could each die with $600,000 before their estate was taxable. Well, if you had a home and a life insurance policy and a retirement account, it was very easy to go over that $600,000 for each spouse. And so what we would do is we would create two separate spouses or trusts. We would create a Ken trust and a Catherine trust. We would separate assets so that we would try and maneuver them into separate assets. And if Ken died first, his trust would take the assets up to that $600,000 so that he didn't have to report any federal estate tax. And maybe, let's say he had $900,000 in his trust, he could give that other $300,000 to the Catherine Trust. And now maybe I've got $900,000, but the thought is, well, you're going to live longer. Maybe you're going to spend that down. And so often, in fact, just this week, I had two trusts that were, one was from 2002 and one was from 1998, separate trusts. And so we often bring those trusts and we merge them into one at this point because we really don't need to have two trusts. And just, as an aside, trusts, you have to understand, when you do a probate administration, it is exactly the same as a trust administration. It's just that the court isn't involved. And so when you have a trust, you still have to do all the rigmarole. It's just that the court isn't involved. And so, and I just say that to say, not everyone needs a trust. We really have to look at who your beneficiaries are, what kind of assets you are. They're easy to get to one another. But sometimes we'll do separate trusts if it's a second marriage. That is where I find I will do second trust quite a bit because we might want to segregate assets because we have assets going to this spouse and their children and this spouse and their children, and we might want to separate those assets for individuals. So sometimes in a second marriage, it's very situational, but I would say probably more than 95% of the time, married couples can get by just fine with a joint trust. Yeah. I think that I've covered everything on my list, so I don't know if there are other questions. Yeah.
So executors, trustees, all the fiduciaries, all the fiduciaries. Those F words. I'm just kidding. I know I had asked before about co versus successor.
Yeah.
In those capacities.
Yeah.
Code.
So, a lot of times we appoint co, and again, it goes back to when I'm appointing co, if I'm drafting a trust and someone says, I want my kids to be co-trustees. So usually with married couples, if you do a joint trust, there's always co-trustees. Banks never have a problem with that, ever. They're fine with when spouses. Where they have a problem sometimes, it's where, both the settlers, mom and dad, have died, and now we've got Chloe and Mallory as co-trustees. And so I will ask my clients, how do you want the authority to go? Are you okay that Chloe and Mallory can act independently and they don't have to have joint decisions? Or do we have to have joint decisions? Do we have to have unanimous decisions? Because that may impact how the banks might treat that trust. And so, our job is usually to make sure that there's a very easy flow of events. And so if we have co-trustees, we have to spell out very clearly for the entities, hey, we've appointed two people to act, and when they are acting, here are the rules for them. They can act independently. They don't have to act together because banks want to know, what are we supposed to do? How are we supposed to treat these co-agents? So I would say, yes, we do that often. We just have to make sure that when we're setting it up, we're meeting your goals. Why are you appointing co? Are you appointing co because this is going to be a lot of work and I don't want to foist it all on one kid. I want two kids to do it, or I don't want to hurt someone's feelings, so I'm going to put them together. And then I'm going to be not pushing back, but I'm going to be exploring with you. If we name Chloe and Mallory, can they do this together? Because I have had situations where someone's died, the co-trustees come in to see me, maybe I've never met them before, and those two can barely be in the same room. And I'm thinking in my head, oh, the heck are these two going to do this trust administration when they can barely get along? And so, there's just a lot of dynamics to that. But it's I would say the answer to your question is, yes, you can do it. And it's very situational.
Right. But, and you just talked about bank accounts. Let's say somebody's like, well, things aren't going to go to a trust. I'm just going to have a will and co-executors. And then you've got all these little different pieces that
So in that scenario, if you're just going to have a will, then my thought would be, I'm not going to let you walk out of there with the thought that we're going to use those co-executors. My goal is going to be that they're never going to do that job, because we're going to put the two of them as beneficiaries on the account, and we're going to do a ladybird deed, and we're going to have beneficiaries on the IRA and on the life insurance, so that nothing ever goes through that will. Because when you have a will, I'm going to try and keep you out of probate so that we never use it. It's just there as a safety net. But if we did have to go through probate because that bank account didn't have beneficiaries on it and there were co-executors, then they're both going to have to go to court, both petition the court to say, we're both named as the personal representative. We both want to be the personal representative, and the court's going to appoint them as co-personal representatives of the estate and give them a document giving them their authority. It's called letters of authority, and they will each have a document saying that they have authority to act on the behalf of the estate. And just so you know, if you are named as a fiduciary, you're named as a trustee, you're named as a patient advocate or durable power of attorney, it is not indentured servitude. You do not have to do it. You have every right to say, yes, thanks, but no, I'm not doing it. And then it moves to the next person. So, it behooves us to ask the person that we're going to name, do you want to do this? This shouldn't be a surprise. This should, when you die or become incapacitated, someone should look at the document and say, what? Are you kidding me? It should be something that you've talked to them about, because I'm just going to tell you, has anyone ever acted in that capacity for anyone?
Yeah.
It is a lot of work, right? I mean, it is. Sometimes I say, you know what? Name the kid you hate the most. I'm just kidding. I'm kidding. Maybe. Right. Right. And I'm kidding. But it's a lot of work. But you have every right to say, and so if you named co-executors or co-personal representatives of your will, they have the right to say, I don't want to do that. Or, they might talk between them and say, you know what? When mom and dad did this, we both lived in Grand Rapids. Now I live in LA. I'm just going to say no, and you just do it. So, but you can definitely do it. And it's just something, it's like all estate plans. People will ask me, what do other people do? And I'm like, that doesn't matter. What we have to do what's best for your family, for your situation. And let's talk about your family and not what other people do. Go blue.
I have my daughter in my will trust, and she's getting divorced. So I don't know how she's got it set up in her will and trust. But how do I find out? I got to go through her to make sure he does not end up with anything of mine.
So he's probably not part of your estate.
No.
You haven't named him, right? Okay. And so
Then if I die, it goes to her. Notice she died a week later.
So usually, and I'm not a family law attorney, can't do your divorce, but most of the time in Michigan, inheritances are not part of a marital estate unless you commingle that money. So if my mom died today and left me $1 million, I would not be here. I'm just kidding. And I kept it in a Catherine-only account, and then my husband and I got divorced, that's generally not going to be part of a marital settlement. But if I inherited $1 million and I said, oh my gosh, Ken, let's put this in our joint account, and we use it, we buy some stuff with it, we buy a joint house with it, that becomes marital property, and that would get separated. I'm sorry, that would be separated in a property settlement. But usually inheritances are not part of a property settlement unless they're commingled. And there's obviously, other things that could happen in a divorce. But not usually, when you get a divorce, like when she gets divorced, her estate plan will be null and void. So whatever she's got in her estate plan, she'll need to redo, because the court says, hey, you're not married anymore. You lose all marital rights, and those estate planning documents are no longer valid. So anything that you have in your estate now wouldn't go to him. And if you died in the meantime, it shouldn't go to him as long as she doesn't commingle it. So if you go home today, give her a little call. So.
to piggyback on that, how often should somebody review their estate plan? Like, for instance, when we put ours in place, we had one kid, now we have four, and the people that were supposed to take care of our kids are now divorced to live in Arizona, so they don't even know how we should update that one.
Like last year for you. Yes. Yes. That was last year. Yes, right. Yes. You need to do that. Yes. So you should update it. You should look at it. You don't necessarily need to update it, but you should look at it every few years just to say, and I always like clients to do a little summary of their estate plan so that they can just look at their summary. This is what I have, who's in charge, but, look at it every couple of years just to say, is this still relevant? Currently we have our trust says that if we die, the money that goes to our kids stays in trust for their lifetime, because when we did our trust, they were littler. And my husband and I just, I'm embarrassed to say this, it's been a while since we've done ours, but, and yes, right, it includes all of our kids. But, they're getting to the point where we would be okay with, if we died, they could get some money in a few years. So we're changing our trust to say, when we die, it goes to our four children, and it'll be held in trust until they turn 25. Two of them are past 25. So if we died tomorrow, two would get their money, and the other two, it would be held for them as they finish school. And once they hit 25, it would go to them. So every couple of years, you should look at it. But if in the meantime, one of your fiduciary dies, or you have a change of circumstance, a child gets a divorce, you get new grandchildren, you move, you get new property, you sell property, that's a time to look at things and say, is there an update that we need here?
Is there anything you'd do different if you owned business? Should that be part of the trust, or is that a separate?
It depends on the type of business and is it a solely owned business? Is it a business that you own with other business partners? Because there's going to be some business documents that govern how your share transfers. And most of the time in businesses, if you own it with someone else, there's going to be some document that governs what happens when you die. Because, when I had my own law firm, I had a partner. And law firms are a little different because you can't own a law firm unless you're an attorney. But I certainly wouldn't have wanted to own my law firm with his spouse if his spouse was an attorney. I wanted to be a partner with him and maybe not someone else. And the same with other businesses. Most business owners don't want to be in business with the spouse or the children of individuals. And so we do include business succession planning that should be part of your estate planning, because if that business gets sold, let's just say that the business documents say that the other owner gets the first right to buy out the estate of the dead business owner. And so now that money comes to that estate. If it's to the estate, it's going to go through probate. So maybe we're going to assign that to the trust. We're going to assign that interest in the business to the trust. And, it depends on how complicated the business is, but absolutely, if you own a business, that should be part of the trust or the estate planning consideration. Boy, this was a lot. You guys asked good questions. Yeah.
Okay, you're probably not going to be able to or willing to answer these.
I can't do your divorce. No, I'm just kidding. I know. I'm kidding.
What kind of cost is a typical estate plan?
Yeah. So I would say that a typical estate plan, if it doesn't include a trust, is usually anywhere between $1,500 and $2,000, depending on if you have a ladybird deed, how much funding you have. I would say trust planning, if you add that trust in and some other trust planning, it usually is going to be between $2,000 and $4,000. And that's just on average of my unofficial polling of my colleagues at various firms. So, but I would say if you're paying more than $4,000 for your estate plan and you are an average individual with a house, bank accounts, life insurance, if your estate is under $10 million, if you're paying more than $4,000 for an estate plan, get a second opinion. And I'm going to say one other thing then. Irrevocable trusts. There is a concept of these irrevocable trusts, Medicaid planning. You don't want the government to steal your money. I'm very, very conservative when it comes to recommending irrevocable trusts. And so if someone recommends an irrevocable trust to you, I would definitely ask for a second opinion, because what people don't understand, I have clients on a regular basis come in and they've done an estate plan and they have an irrevocable trust, and they've been told, you got to put this stuff in this trust because if you need nursing home, the government's going to take your money. And so they put these assets in this irrevocable trust and no one explains the irrevocable trust to them. When you put money in an irrevocable trust, what you're doing is you're creating a box and you're slamming that lid shut. And you're saying to the Department of Health and Human Services, in 2026, I put this account in this trust. And if I don't need Medicaid for the next 5 years, but after 5 years I apply for Medicaid, this box is protected. You can't look at it. And that is very true. But what happens, I see all the time, is that people create these irrevocable trusts and attorneys say, oh, your IRA, that irrevocable trust is a beneficiary, so it never got in that box. And the reason it didn't get in that box is because if you cashed out your IRA and put it in that box, that's a taxable event. You would pay taxes on that entire IRA. Or they put assets in that box and they don't know that they're not allowed to use it. And I'll say, well, I'm looking at this estate account for this irrevocable trust and there's money in and out. Oh yeah, we use that all the time. Well, you can't, because what you're saying to Medicaid is, I put it in this box, I'm giving it away. I can't touch it anymore. You, by terms of that trust, are not a principal beneficiary. And so those irrevocable trusts are very niche and very few people need them, in my opinion. And that's just my opinion. So get a second one on that. But I just worry because I see a lot of people with irrevocable trusts and they pay a lot of money for them. And most people don't need them. Most of the time I'm undoing them.
Is it possible to protect your assets if you go into long-term care?
Absolutely. And you don't need an irrevocable trust to do that. Yep. So thank you so much. This was a joy. Peace. Oh, I like this one.
Thank you, everyone, for your time and attention today. On behalf of Melinda, Jeff, Anna, and myself, as you know, we are health insurance agents and focus on health insurance and Medicare. However, we put on these Thursday appointments every third Thursday from February through October, and we would love to have you visit us again next month when we have our new plan. So thank you for your time and have a great night.
Think about what you will continue.